first of all, thank you to Deputy Director General Revalo and his staff, as well for their collaboration with the IPK team of the EUIPO for setting up this wonderful event, and of course to the EU delegation here at the Philippines and their representation and collaboration. So we're meant to kind of kickstart the substance of the day by speaking about how we handle IP mediation at the EUIPO. Now, before we get going into that, I just want to say it's a very important day for me, because over the past few years I've been collaborating with the Southeast Asian colleagues and IP offices quite a bit on different IP mediation workshops, but always online due to the COVID situation. So this is my first opportunity to actually be here in person and meet some of you, and is really wonderful to be able to do that. So both for the local Filipino, whether you're from the national office or whether, I understand we have some legal practitioners here as well, which is great to have, and also for the other colleagues from the different Southeast Asian countries. It's really wonderful to be here, but even more so as I'm here with Mr. Luwin de la Concha. Yes. He's been with us in Alicante for about 2 years now. He's an expert in mediation, as you heard, and it's been wonderful to work together with him and learn a lot from him, not only about how things are done in the Philippines and Asia, but in general, his IP mediation background. So I'm going to ask him to maybe introduce us to this presentation. Thank you.
Yeah, thank you, Goran. First of all, I would like to thank also IPK for having me here. I will be just backstabbing with Goran because this is actually a more he would be more expert in the procedures in EUIPO, but I will just give some background in terms of how they conduct the mediation in EUIPO. So can I have the? And I will be staying on the other side as well. Okay. So okay, so first of all, this is the topics we will discuss in this presentation. We will be introducing the European Union Intellectual Property Office Mediation Center. After that, we will go over the services that they provide, as well as the legal framework that gives them the procedures or the rules in such services. Then we will go into the features. What are the services? What are the features of what the benefits of mediation in terms of the EUIPO business program, and a little bit of statistics as well. And we will go into the detailed procedures and process and in the EU mediation service. We will present our mediators and give you a little bit on how they accredit the neutrals in EUIPO. Then lastly, a little bit on stakeholders engagement and how do we promote our services to the EU as a general community. Okay. Well, to give you a perspective, the mediation in EUIPO has been in existence since 2011, but the mediation center has been newly established. In fact, it's established on the 22nd of November 2023. And with these slides, it says that the objective of the mediation center is to provide complementary, voluntary, and confidential and accessible dispute resolution options to users so that they can choose the most appropriate path in the event of an IP dispute. So meaning there are several paths, there are several services, and all of them are provided for the stakeholders and or the parties in dispute. Okay, just to give you a perspective, how do we arrive at a certain case where the case is eligible for mediation? Well, to tell you, there's a huge potential for mediation in terms of the procedures of in EUIPO. First, once an applicant submits an application for trademark or a registered community design, it is examined by the examiner from the operations department, and they analyze it whether it could be registered, or it may fall under the absolute ground, which is subject for refusal. If the applicant would like to pursue his application, then he could file a proceedings, and this will be called this will be an ex parte proceeding. So in that case, the dispute is not since the EUIPO is part of the dispute, it's not eligible for mediation. However, if the case of if the application is deemed appropriate, then the EUIPO will publish the application for opposition for 3 months. So within that period, any entity could file for an opposition for that application. So in that case, it becomes an inter partes case. So for all inter partes cases could be eligible for mediation. So just to give you an idea, the EUIPO receives around 200,000 EU trademark and around 100,000 registered community designs. So they have a huge application in a yearly basis, around 300,000 IP rights application per year. So out of this 300,000, around 20,000 oppositions received, and around 2,000 cancellation, as well as 250,000 appeals. So in total, there's around 24,500 disputes yearly. So imagine the volume of disputes that they handle. So in the EUIPO procedure, mediation is very successful. We have attained at 70% settlement rate, and as around 80% based on the customer feedback, and 80% user satisfaction rate. So it's just this goes to show you the volume and the effectiveness of mediation. Would you like to add to that?
That's wonderful, Luwin. It's really one of the reasons why they thought mediation might be very helpful is precisely because of the volume. So the more cases we could get resolved without having to take a decision, it could provide benefits not only to the parties by having those tailor-made solutions without a decision, but also to the office with having less decisions to take. So
Yeah.
thank you.
Yeah, I think so. Yeah, so imagine the potential for the impact of mediation in terms of the volume of disputes in the EUIPO. Okay, so this is our services in the EUIPO. First is mediation. This is the flagship service. Of course, the purpose of mediation, the objective is to reach an amicable settlement with the assistance of the mediator. The mediator is always deemed as impartial and neutral, and the parties are supposed to be the main actor in the mediation process. After this gives me something and a thought that I read once in the paper that a certain mediator said, I have successfully mediated 2,000 cases. However, I have not settled a single one. Do you agree? Do you agree? It's because the mediator doesn't have the power to settle. It's the party who decides the settlement. Okay? So they also have mediation, conciliation. In conciliation, the conciliator may suggest possible solution to the case as to the substance of the dispute. Of course, the conciliator is deemed impartial, as like a mediator, and impartial and neutral in this case. But in conciliation, it is the rapporteur or the examiner who always assumes the post of a conciliator. Okay? And in terms of this mediation, this is actually unique to EUIPO. They have what they call expert determination. So, if the parties have this deadlock in terms of certain issue, whether it's legal, economic, or technical, they could request for an expert determination. Okay. In this context, the party, this expert will will assist the party in reaching, in giving an opinion on the issue at blocking the negotiation. So, and they also in EUIPO the examiner could also propose a friendly settlement. In this case, the parties are invited to negotiate between and among themselves. The case handler doesn't have any position, or it doesn't assume any position, or doesn't assume any involvement in the negotiation. So it's only the parties themselves who negotiate. So it's a friendly settlement. And then lastly, to support and in the management of the ADR procedure, the EUIPO has established an online ADR platform where the parties could communicate in a very confidential environment. So this is actually a software, software which the parties could use during the proceedings, even at the start and at the start and end of mediation. So this is very very important in terms of providing the service in EUIPO. Okay, I think I will pass it to Goran for this part. Okay, you could just I could just give me you.
Yes, thank you. So the next part of the presentation is to talk a little bit about the legal framework that we have, basically giving us the basis for offering these services to our users. Now, as I see, we're a bit behind on time, and I don't want to stand in the way of anyone's coffee break. I think one of the best things to skip through quickly is the legal part, because sometimes it tends to be a bit more dry, firstly. And at the end, we want to be more focused on mediation, because that's how to avoid the legal stuff. But it's good to know. It's true that maybe for the practitioners here working in the Philippines, the EU legal framework is not very relevant. I appreciate that, and we would go very quickly through that. So we'll try the next slide. So we do have in the EU, we have a directive on mediation in commercial and civil matters, and it's an attempt at harmonizing basically the practice and the offer of mediation services throughout the 27 member states that make up the EU. So you can imagine as it's challenging to have a framework that's acceptable by all 27 different nations, it's very general, this directive. So in my view, now being a mediation enthusiast, for me, it doesn't go far enough, but it's because it's very difficult to go very far. What it does is it recognizes mediation as a thing, as an important thing. And I think this is an important step, that it is recognized in legislation. But beyond that, it's probably not giving too much. It gives us some basic definitions, and it talks about how mediation could apply in cross-border disputes. That's of course very important in this international context, and it defines mediation and mediator. But little more than that. We can go to the next one. So it does give 5 substantive rules that how mediators are to be trained, but in a very general way, that they have to be trained effectively. The judges can invite the parties to mediate, but they can invite. So there's actually, going back to what Deputy Director General Arevalo said earlier, and I laud you and your office for this, you've managed to make mediation mandatory. This is wonderful. If people would listen to me in Europe, we would do the same thing, but we're not quite there yet. So, but you know, we do have the possibility for judges to, let's say, invite the parties to try to settle their agreement with a mediator outside of court. There's some really basic provisions for how settlement agreements reached through mediation can be enforced in the member states. So we recall that these are contracts, and how do we enforce contracts? And then we talk about the other fundamentals of mediations, like confidentiality, and that you never lose the possibility of receiving a judgment or a decision in your case just because you tried to mediate. So then we go to another, it's basically not even a law. It's a document where the European Commission with a group of stakeholders basically penned something called the EU Code of Conduct for Mediators. It is exactly what its title suggests, and what it does is it provides some very general principles, mainly about how a mediator is supposed to behave, okay? And you see them up there on the slide. I will not go into too much detail to try and make up for time, but they're really kind of, for all, I think, if not all of you, a number of you have gone through mediation trainings or accreditations. This kind of, let's say, repeats all of the fundamentals and basics of how a mediator is supposed to behave in a general sense, and it's done in a document. It's not actually a legal instrument. So thank you. And then we get to our office, the EUIPO, where we've actually had legal basis to provide some sort of ADR basically since the founding of the office, okay? And this is the facilitation of amicable settlements. You can see that exists in the trademark regulation, in the previous one, in the current one called the EUTMR. It exists in the design regulation. More recently, it has also been included in the GIs for craft products, so for non-agricultural products, that's been adopted by the European Union. And naturally, it might be included in any other IP legal instruments or regulations that will come up in the future. Meaning, any, as Luwin said, explained very nicely, any inter partes IP conflict in the EU would benefit from free mediation services from the EUIPO, okay? Now, the main article for our mediation center, and it's quite a substantive article because it's about 2 pages of legal text. So Article 170 of the EUTMR really gives what in my opinion is a very detailed breakdown of how our mediation center is supposed to be structured, function, and behave towards the users. So that's more or less it. I think we may have had one more slide on this, Luwin. Yes. So then what we did was we took that Article 170 and we kind of took it a bit further so that users know exactly what they'll be getting themselves into if they decide to mediate at the EUIPO. We made an executive director decision, that's the equivalent of our director general, on the establishment and the operation of the center itself. So basically this talks about how we behave when we're asked to provide mediation services and how we're governed as well. And then we made another decision of the executive director called the rules on mediation, and this is even more detailed. This means that basically, especially the IP legal representatives, when they're going into a mediation, they have a very concrete document with instructions about how to behave, and they should use this to inform their parties, their clients, so that they're prepared going into the mediation. We also will get more into this tomorrow about how we train our mediators and how they're appointed to become mediators of the office. And then finally, Luwin mentioned earlier the conciliation process, which is driven by the examiner or the rapporteur at the appeal stage. Well, this is actually in a separate document called the Rules of Procedure for Appeals, okay? Because in fact, it's conceptually, it's deemed that the conciliation happens within the appeal. It's not a separate outside process the same way that a mediation would be. So this is what we have in-house that we've developed to try and help our users navigate through the different possibilities of alternative dispute resolution before the office. Now, I think I'm actually going to skip this. This is where we go very detailed, and I believe we don't have time for that. I'm a bit sorry about it, but maybe this is the part we could click, just make sure. Yeah, it really gets a lot, but it's going into further detail on the aspects that I just spoke about. Can click again. This is conciliation, what I just talked about. One more. Okay, back to Luwin.
Okay, yeah, thank you. Well, these are the features. So these are the you could say as the uniqueness in the EUIPO mediation service. Okay, first of all, if you go into mediation, it entails no additional cost to the parties, aside from the relevant fees for opposition and cancellation. Basically, the service is provided for free, the mediation service. Then, IPO mediators are members of the staff in IPO and are IP experts, and they are trained by internationally recognized training institutions like the IMI, International Mediation Institute, or LSM, the London School of Mediation. So it gives you the how they value accreditation in EUIPO, and most of the mediators are multilingual. They could provide language requirements for the 5 languages in EU. Okay, and like I discussed before, we have this very important online ADR platform, which is very confidential. EUIPO has invest substantial financial effort in providing this unique platform to users. Okay. Well, this is just how do you go into mediation. So it says that your entry point is inter-parties cases, where once you apply for trademark, and there will be an opposition cases. Then once you pay the appropriate fee for this opposition and cancellation cases, you are eligible for mediation. Okay, but it doesn't exempt all other cases or which the parties could include it during the negotiation, whether this could involve other RP rights like copyright, domain name, or any other pending disputes. Anywhere in the world, meaning if these cases are in the courts, they could involve it in the negotiation and in the settlement of the dispute. And they could request mediation at the opening of the adversarial part of the proceedings. So at any time.
Yes, and I think this is an important aspect that probably in today's context we want to take some moment to take note of and hopefully even discuss later on, especially with the colleagues from the other IP offices. We know by nature that many IP rights are very international in the sense the business is international. They might offer their products or services or both throughout the world in many different countries. What does that mean? That means that when an IP dispute comes out, by its nature, it often tends to be international. It's not only in Vietnam. There could be some that are only in Vietnam, but it's probably also in the Philippines, may as well be in Europe. All that to say is that we might actually be dealing with the same cases or very similar cases at the same time, okay? Now, at the beginning of the slide, you see the entry point is that there are pending inter partes proceedings before the EUIPO, right? Meaning we would not be able to mediate for free a case that is only in Vietnam. But there could be cases in Vietnam that are also pending cases before the EUIPO, in which case the parties could request our services. And sorry for using Vietnam as the example, but it could be, I think, really any other country in the world, and definitely in Southeast Asia. So one thing I think we could jointly think about in the future is how to let one another know when we know that we have cases in common, and especially when they're complex international IP disputes that perhaps could benefit more from a mediation than from a number of different decisions that may each go in a different way. They may not even end up with the same conclusion. So all that to say as well that it's interesting once you start dealing with the parties in these types of contexts, because we had, last year, we had one mediation that covered 70 different proceedings globally. And when I was speaking with the lawyers, in fact, they weren't sure if it was actually 70 because they were working through so many different agents in all of the different countries around the world that they admitted that their inventory of ongoing proceedings was not 100% precise. Meaning, these things come up, and maybe if possible in the future, we could find a way to work together, identify such cases, and kind of help those parties resolve them without taking 70 or more different decisions separately. So thank you.
I think that's a good proposition. Yeah? Okay, so just some statistics again. Well, since during the 2012 and 2024 when this mediation in EUIPO has been in place, we have received 230 ADR service cases, which also involves mediation and cancellation, and around 50 settlement quarterly for like friendly settlements. I think this is a good part of the settlement in of cases, and at the same time, since I think there's a tremendous growth of cases in EUIPO, we have more than 188% increase in cases, growth of cases in the mediation center just recently, I think. Yeah. Okay. So would you provide this one?
Yes, thank you, Luwin. Yeah, we're a lot busier since the launch of the Mediation Center, as you can tell with that growth. But maybe we're going to quickly talk about how the process works at the EUIPO. Again, try and just skip through it. So Luwin already explained extremely well that you need the inter partes case before the office. Okay, so that's the starting point of everything. Now, if you have one, you can request or unilaterally the lawyer and their client, or jointly, meaning both parties can request mediation. As soon as the parties agree, so as soon as there's two separate requests for mediation, those formal proceedings are suspended by the relevant instance. So it could be at first instance if it's an opposition or a cancellation, or the boards of appeal if it's an appeal, okay? Once the parties are informed that the case has been suspended is when the mediation center is triggered, okay? So we get in touch with the parties, and basically what we do is we look at the characteristics of the case, in particular the nationality of the parties and the representatives, the languages that they use, and maybe even the type of commercial sector that those trademarks might be operating in. Based on that, we look at our pool of mediators and we try to find an available one that best suits the needs of these parties. We propose that mediator to the parties. Under Article 170 of the EUTMR, this is where the legislator became very specific. They have 20 days, 20 calendar days, to say yes or no, okay? And if they say no, in fact, the suspension is lifted and the formal proceedings recommence. Okay. But normally, maybe go back one. Thank you. Normally they say yes. In fact, we've only had a couple of situations where for nationality reasons, one of the parties said no. So there would be, let's say, a Belgian and a French company, and then we would propose a French mediator to speak French, and the Belgian would say, no, we don't want a French. And okay, so we would find a German person who also speaks French, and then that would satisfy everything. Normally it works, but these are the types of things that come up. When they say yes, we set them up with the mediator. The mediator basically handles the substance of the mediation with the support of the mediation center. And at the end of each mediation, the suspension is lifted. Depending on what happens, the next steps would be either the withdrawal of the formal proceedings if there's been a settlement, or the resumption of the formal proceedings with a decision on the merits. But as you saw in the statistics, once parties accept to mediate, in 70% of cases, it becomes withdrawal of the formal proceedings. So yeah, we'll continue. This slide shows how you can request it. You can go to our website of the Mediation Center. Okay, there's a tab for requesting ADR. You get a form. You need to fill out the relevant information that's asked related to the case, sign and submit it through the EUIPO user area. So the EUIPO user area is the platform. It's the front office for all the formal trademark and design related matters. This is how the IP representatives and the parties communicate with the office, and it's the same platform that's used then for requesting a mediation as well. Okay, I think we're gonna have to skip through all these slides. I rather did it in the same one. So this explains the suspension. Again, you see Article 170 there. Maybe quick distinction is that the Article 170 mediation suspension is different than the suspension that the parties can request in formal proceedings, because it's actually tied to the duration of the mediation. So those proceedings are suspended until the mediation finishes, whereas all other suspensions are up to 2 years and have to be renewed on a 6-month basis, okay? So that's a big difference. We'll skip. These are our lovely mediators for now. So you can see that there's a big variety of people from many different EU countries and speaking an impressive, I have to say, amount of languages. Sometimes dealing with these people blows your mind a bit how quickly they can switch from one language to another, and they do also have a lot of different cultural experience that helps them deal with international businesses in mediation.
Yeah. Okay. I just like to add, we have I think several years ago we have with us Gordon and Cynthia as one of our speakers also. So I think most of them, IPO Mediator would know both Gordon and Cynthia. Okay.
They managed to make it here before the pandemic, so.
Oops, there's a, can I?
Yeah, go ahead.
Yeah, this doesn't work now.
It's not, it's the,
can you
do you have
change
another?
the slide then? Okay.
Okay, on the platform, we're going to talk more about it tomorrow, and this helps us skip through. But again, I would like to comment on something Deputy Director General Arevalo said earlier. And again, I laud and congratulate you on your end-to-end platform that you have for mediation. That's, I can say now from experience, this is a tremendous accomplishment, because we did launch our platform a year ago when we launched the Mediation Center. So the two launches coincided. But from personal experience, I can tell you, to me, it's not quite end-to-end yet. I think we're missing some of the steps. We're still in a customization phase with the service provider. It's extremely complex. It works really well for certain things that we'll talk about tomorrow. We have gaps still that we need to address, but I'm looking forward to the day that we can also say we have an end-to-end platform, but we'll keep going. We'll talk more, I think, about this tomorrow, so we can
I think so,
skip through.
Yeah.
Keep going. This, I also think tomorrow when we get into the practical part, as everyone here has pretty much been trained in mediation already, you know the roles of the parties, you know the roles of the lawyers, what a mediator is supposed to do and not do, so we won't bother you with that now, but we might bother you with it tomorrow. Okay, so this is tomorrow. Actually, I'm going to do a bit of a spoiler right now. We were planning tomorrow, as it's going to be quite a heavy day today and tomorrow, that after lunch we have a look at some videos that we've prepared, if that's okay for everyone. These videos are meant to give kind of practical situational examples of what happens in a mediation. And there we're going to go over all of these different phases in a mediation. So we don't need to go into any detail there now. Yeah. And this we're going to have to skip through. Maybe I give a very quick summary. One of the things, when we were embarking on the launching of the Mediation Center, or so it's been about a process of about 3 years, we thought a lot about what sort of cases are suitable for mediation. So clearly one that we've already mentioned is when there's multiple proceedings, right? An international dimension, meaning many jurisdictions, maybe different cultures, different languages of the parties, so on. So what we did was we actually, we have a judges network where the judges of all of the EU trademark courts come and join us, but not to talk about the law, to talk about ADR, okay? How we can solve the cases, help parties rather, solve the cases without taking decisions. And jointly with them, we brought together these 10 reasons that basically help people identify their case as being suitable for mediation. We think it's quite useful actually for lawyers to think about when they receive a new case or a new client, and they look at it, maybe they could compare it to this checklist and say, should I maybe consider, I mean, it doesn't mean you have to go to mediation, but at least in your initial assessment strategy or your initial consultation with the client, maybe it's worthwhile to think about whether it should be done. Now, we know in IPOPHL, you have to do it, so you don't have to ask yourself the question. But for us, it's been very useful as a promotional material. So in fact, if you go on our website, you also see it in the brochures that you all received at your table. And you will see it on our website. But if you go on the EUIPO website, there's a part of the EUIPO called the Academy. The Academy has a lot of interesting IP-related training material. And one of them actually is a webinar on these 10 reasons. So if you're ever bored and want to see, it's about an hour from what I remember, you could sign up for the EUIPO Academy. It's very easy to create an account. And then you could look for mediation-related webinars, and you'll find a number of them, one of which is on this one. So I think we'll continue. I think, okay, maybe we'll skip through this one quickly as well. So tomorrow, the first session, talks about how we accredit and train our mediators. Basically, they start out as staff, decision-taking staff. They're examiners, rapporteurs, members of a board of appeal. They start with the accreditation training, but then after the accreditation training is when the internal and practical part of their development happens. So we're going to go a lot more into detail on that tomorrow. I don't know, is there something you want to add on that?
I just like to add that for 2024, we are, I think, in response to the increasing cases that we have in EUIPO, we are planning to accredit more mediators, probably 20 or 20 for at the end of this year, and this will include Goran as part of the mediators list. Okay.
Very true. Thank you.
Okay.
Yeah, let's see if we can get through this so we can have a coffee.
Yeah.
You want to do this one very quickly?
Yeah. These are the, aside from the handling of cases, the mediation center is involved in promotion, collaboration with stakeholders on mediation. So these are the some of the activities that we are involved in. Of course, we have conducted 20 events with similar to this one, either online or face-to-face or presential seminars. There are joint awareness campaign to promote it to SMEs, to lawyers, and all other organizations. This stakeholder network is very important to EUIPO. I think this involves stakeholders engagement, and it's part of an overall engagement plan that the office is implement. And we also involves in sharing of best practices and learning with our partners. So there's a network of judges which regularly meet in Alicante for sharing of sharing of practices and experiences, and also bilateral cooperation similar to the IPK program. Okay, I think that's more or less our presentation.
I think we managed to get through it in the 45 minutes we had, but we started a bit late. So I think in the interest of time, we're going to now maybe start the coffee break, John. What do you think? Yeah? And I just want to say before we go to that, I'm sorry that we didn't have any time for questions in this specific presentation, but during the coffee break, during lunch, we'd be very happy to hear from you and talk about anything that's on your mind. So please, we'd be grateful if you approach us. Also, I think tomorrow there will be a lot more time for discussion. So even if you have a question from this presentation from today, feel free to bring it up in any of the discussion segments tomorrow. So thank you very much for your attention. Thank you, Luwin.